Major breaking news. We had the en banc argument. The entire Court of Appeals for the Third Circuit overseeing Delaware, New Jersey, and Pennsylvania deciding today whether or not New Jersey's insane ban on AR-15 semi-automatic rifles and magazines that hold more than 10 rounds, is this constitutional or not under the Second Amendment? And yes, indeed, folks, I'm happy to report that Judge, the Honorable Jennifer Mascot, did indeed participate. Thank you for your attention to this matter. We'll talk about all this when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, we have a lot to talk about. We're probably going to have to do a couple different videos, but we're going to start right here and right now. This morning, we had a major oral argument in the city of brotherly love, Philadelphia, Pennsylvania, in the Cheeseman and the Association of New Jersey Rifle and Pistol Clubs cases against the state of New Jersey as to whether or not the ban on AR-15 semi-automatic rifles and magazines that hold more than 10 rounds, are these bans under New Jersey law constitutional, consistent with the Second Amendment? Big fight today. The entire U.S. Court of Appeals for the Third Circuit participated. This was an en banc review. Just to jog your memory how we got here, and then we're going to break down the argument today. There was an argument in this case, or these cases, many months ago, in front of a three-judge panel. The three-judge panel obviously circulated internally their draft opinion, which is consistent with the Third Circuit rules. They circulated their draft opinion on behalf of the three-judge panel to the entire Third Circuit. But rather than allowing that three-judge panel to issue its ruling, presumably against the Second Amendment, because the panel that heard the case was a terrible panel. It was clearly an anti-Second Amendment panel. We know that 6 ways to Sunday, and we were 100% going to lose that panel decision. The Second Amendment was going to lose. But obviously that draft opinion was circulated internally to the U.S. Court of Appeals for the Third Circuit, and the entirety of the Third Circuit decided they did not want that panel opinion to be issued because it would be binding on the court going forward. So instead of allowing the three-judge panel opinion to be issued against the Second Amendment, the en banc entire Third Circuit basically voted internally to hear the case en banc, and they stopped that opinion from being issued and then heard argument today. In addition to that, as you know, I brought this to everyone's attention in the middle of September that the Third Circuit had an open seat in Delaware. There was an open seat available for President Donald J. Trump to fill. And Donald J. Trump did indeed fill that slot. He nominated to that vacant seat in Delaware for the Third Circuit Jennifer Mascot, a professor of law, former Clarence Thomas law clerk, former Justice Brett Kavanaugh law clerk. And there was a big debate. Could she get confirmed by the U.S. Senate? And she was. Would Donald Trump sign the commission, which needs to be signed for her to take her seat? He did, before he went to the Middle East, by the way. And yes, indeed, she was sworn in. And as of this morning, I'm happy to report that Judge Jennifer Mascot did indeed participate in this oral argument, which, as you know, was a very big deal that I've been hammering home on this channel and on X at Four Boxes Diner. So with all that set up, here's what happened. The bottom line is, I do not know for sure who's going to win this case. Not all the judges asked questions, but the questions that were asked, I think, were overall favorable to us. And I would bet, if I had to bet, I would bet that we likely will win this case. We will win this case. I think there will be a fine in the AR-15s, the semi-automatic rifles, and the magazines that hold more than 10 rounds cannot be banned under the Second Amendment. So just to give you some of the highlights, one of the big fights that New Jersey put up is they try to argue that the burden was on you and me, the Second Amendment community, in this case, the Second Amendment rights claimants, to show that these arms that New Jersey was banning are not in common use. Because just to jog your memory, we'll get to sort of more geeky breakdown about this in a moment. But just to jog your memory, the proper way to interpret these cases and apply these cases is really quite straightforward. You just have to read the Heller decision by the U.S. Supreme Court, and you can read the Mark Smith opinion in the Harvard Journal of Law and Public Policy about in common use that points out that the relevant case law when you're dealing with an arms ban case is actually not Bruin, it's actually Heller. Heller goes through and defines every term in the Second Amendment. An arm is anything that can be used offensively or defensively. If you're going to ban an arm that can be used offensively or defensively, which is, of course, is all AR-15 semi-automatic rifles and magazines, which are, of course, magazines facilitate armed self-defense, critical component of a firearm. They facilitate armed self-defense, and they're an instrument. All those things are definitionally arms. And because New Jersey bans these items, these objects, these arms, the burden shifts to the government to justify these bans. The way the government has to justify these bans is not by arguing guns are good or bad, but they have to argue historically there's a tradition of banning these kinds of guns. And to satisfy that tradition, the state bears the burden in the context of an arms ban case of simply following the Supreme Court precedent of Heller. Because in 2008, the Supreme Court decided whether or not the District of Columbia could ban handguns. The Supreme Court says you cannot ban handguns. Why? Because handguns are in common use by Americans for all lawful purposes. And as a consequence, they cannot be deemed dangerous and unusual, which is the historical tradition of regulating types of arms. You can regulate arms if they are dangerous and unusual. And thus, by extension, logically, if something is in common use by Americans for lawful purposes, it's not dangerous and unusual. Obviously, in this context where you're dealing with millions and millions of owners of AR-15 semi-automatic rifles, those are in common use. Same with magazines. There's far more magazines that hold more than 10 rounds in the United States than there are semi-automatic weapons, right? Tons of magazines, tons of semi-automatic rifles. So this should be a slam dunk case. But of course, New Jersey put up a good fight with probably the best anti-gun lawyer in America, in terms of making the best arguments that he could make on this record, on this law, based on this history. He did a good job. I think he's going to lose, but he did as good a job as one can do in supporting the gun controller position and supporting New Jersey. So his first argument was the standard is not dangerous and unusual. And therefore, even if you can show something is in common use, meaning it's popular among Americans, you can still ban that gun because it's dangerous. Well, that fell by the wayside, in my view, for several reasons. One of which is, one of the judges pointed out, well, wait a minute, counsel. New Jersey's position is that the standard is dangerous or unusual. Well, that means that you could ban all guns in the United States. Because by definition, all guns, all firearms are indeed dangerous. So if the standard is the state can ban all weapons, all arms that are dangerous or disjunctive, dangerous or unusual, you can ban all guns because all guns are dangerous. So obviously that argument cannot fly. So the New Jersey tried to say, well, no, our view is a little bit different. We think that the state can ban unusually dangerous weapons. Unusually dangerous weapons. But then there was pushback there that standard cannot fly either for New Jersey. Because let's just pause for a moment and think about this intellectually for just a brief moment, okay? For something to be unusually dangerous, for something to be unusual, you first have to determine what is usual, right? In order for me to call something unusual, we all have to have a baseline in our mind, in reality, as to what would be considered usual. So, for example, if I say it's unusual conduct to walk down the street naked, to basically make that statement true, you need to understand that it is usually the case that when people walk down the street, they have clothes on. See what I'm saying? So, too, the New Jersey argument here that they can ban AR-15s and semi-automatic rifles and magazines that hold more than 10 rounds because they are unusually dangerous obviously requires some sort of baseline to determine what would be usually dangerous in American life? What would be usual in American life when it comes to the right to keep and bear arms, right? Keep and bear arms. What is usual? And obviously, if you have tens of millions of Americans that keep and bear semi-automatic weapons, semi-automatic rifles, AR-15s, and magazines that hold more than 10 rounds, it means that the use of those, the right to the keeping of those, the bearing of those is usual. And if the keeping and bearing of those kinds of arms is usual, there's a level of usual dangerousness to them, right? Which means by definition, the keeping and the bearing of those kinds of arms cannot be unusually dangerous because they're ubiquitous. And New Jersey does not really have a strong argument about that either. And by the way, as a side note, the standard is dangerous and unusual because that's what the Supreme Court has clearly said. And even though the dangerous or unusual reference comes from Blackstone's commentaries, he's an English commentator from England, from Oxford. We'll give him a little credit for that over Cambridge, but I set that issue aside. Nevertheless, Blackstone's commentaries are about English law and English history, which has some relevance, but we know that the Second Amendment in America broadened the right to keep and bear arms beyond that was available in England. For example, the English Bill of Rights or the English Declaration of Rights said that only Protestants had the right to keep and bear arms, but in America, it's the people, all Americans, whether you're a Catholic, a Protestant, or whatever. If you're an American, you have the right to keep and bear arms. So we broaden the right, which means by definition, if you broaden the right to keep and bear arms, you are shrinking the ability, the authority of government to regulate or otherwise ban those rights. So even if you want to make the case that Blackstone's commentary says dangerous or unusual weapons can be restricted, that's the English interpretation, but the American understanding of the right to keep and bear arms has always been broader than the English. The other critical point that New Jersey was trying to make here is they were trying to argue really that the fear of weapons, and this is kind of a combination of the New Jersey argument coupled with judges' questions, that because, now this is very interesting, listen carefully folks, you got to understand this argument, what the anti-gunners are saying. If you read the text of the Second Amendment, it says the right of the people to keep and bear arms shall not be infringed. What does the right of the people mean? Now here's key, there's a little sleight of hand here by the anti-gunners. Now, the right answer is the right of the people means the decisions of you and me and all Americans, American citizens. If we go out there and buy tens of millions of AR-15s, that's in common use, we own them. We can keep them. All consistent with the right of the people, because who decides what weapons to ban and what weapons not to ban? It's we the people, the right of the people. We get to decide, and if we decide that these weapons are good for us and we buy them and we own them, we've chosen in the marketplace. Of course, the anti-gunners have a different view. Their argument is the right of the people to keep and bear arms speaks through the people's legislatures. That if the people elect legislators to vote in gun control, that is consistent with the right of the people because we, the people, have voted in legislatures that have effectively banned guns. See how that little sleight of hand plays out? Of course, that's not true because you can make that exact same argument with any other aspect of the Bill of Rights. This is as long as the people pass a law that restricts the right to a religion, the right to free speech, the right to assembly, the right to bear arms, whatever it is, the people have spoken and they can give up their constitutional rights through legislation. That's hooey because the Constitution is the supreme law of the land. Legislation by we the people cannot usurp or undercut the Constitution because the Constitution is up top. Legislation by New Jersey, legislation by Congress is below the Constitution. So if we the people amend the Constitution to take away the Second Amendment, yeah, that's conceptually fine, but that's not what we're talking about here. We're talking about a New Jersey statute that cannot amend the Second Amendment of the Constitution otherwise. And again, as the Supreme Court has said, because this all comes back to Supreme Court precedent, the Supreme Court says that Americans have overwhelmingly chosen handguns and therefore they get to own them, period. They cannot be banned. No way, no how. The next thing, of course, that kind of is worth mentioning here, there's a lot that was going on here, but I think the other thing that's worth mentioning is that there was a big discussion about Bowie knives, which we've talked about on this channel. And basically, they said, well, there's a bunch of regulation of Bowie knives in the early 19th century. But then, I will say the Second Amendment lawyers did a good job saying, ha, 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 that's hooey. Because the restrictions on Bowie knives involved restricting concealed carry. I mean, you could not conceal carry Bowie knives, but I think you could open carry them. It involved some other issues associated with Bowie knives, but none of them involved a ban. Keep in mind that New Jersey is an absolute categorical ban on semi-automatic rifles, AR-15s, and magazines that hold more than 10 rounds. This is a ban. So even if you want to say there's a historical tradition, for the sake of argument, let's assume there's a historical tradition of allowing these types of weapons or allowing arms to, I don't know, be restricted in terms of how you carry them in public. Okay, that's a historical tradition of maybe restricting the mode or the method of carrying guns in public or carrying arms in public. That might be a historical tradition. Maybe, maybe not. But it doesn't matter here because New Jersey did not do that. What New Jersey did is outright ban the possession, the keeping of these arms, as well as the carrying, i.e. the bearing of these arms. So the historical tradition of restricting, let's say, open versus concealed carry of certain types of arms does not justify a ban. The fit between those two analogs does not exist. And the last point that I think is worth mentioning here, and we'll do some other detailed videos breaking down some of these geeky points. The other point that I think is worth mentioning is at the end of the argument, the lawyer for the Second Amendment community, Second Amendment rights claimant, made a good argument pointing out that using the right to keep, which means to keep, the right to bear means to carry, proves that the mere possession of arms is protected. Because, of course, New Jersey was trying to say you have to actually use the guns in the context of a bad guy walks in the door and you go bang, bang. And because that is not common, none of these things are in common use, but that's hooey. Because the mere possession, as you know, is the right to keep. The right to keep means to possess, and if you possess the gun for self-defense, you possess the gun for any lawful purposes, you're keeping the gun. If you're carrying the gun for self-defense, you're carrying the gun for other reasons, you're carrying the gun, you're bearing the gun. There's no obligation to any of the Supreme Court precedent that talks about how many times people fire shots. It's the mere keeping of the gun and the mere carrying of the gun that is protected. All in anticipation or at the ready, if you will, in case of a potential violent confrontation. That is the right to be at the ready with guns in case of confrontation. I think the Second Amendment rights claimants in the rebuttal, did a pretty good job on that point, as opposed to what the New Jersey argument is, which is that you have to show that it's common to use these types of guns that go bang, bang when an intruder walks in the door. But that is not the right. That is not the test. That is not the standard. That is simply made up in the fevered minds of academia. So there you have it, folks. The argument went on for about an hour and a half. I'll break down other things. I'll try to play you some clips and we'll discuss them, dissect them. There's some critical, geeky things that we're going to have to break down in a serious way. Oh, as a side note, I should let you know that I'll be speaking in November at the Federalist Society National Lawyers Convention. I'll be giving the big speech, or one of the big speeches, on the right to keep arms in the Second Amendment, but we'll talk about that more down the road. In the meantime, thanks again for tuning in. I appreciate your support. Make sure you follow me there over on X at 4Boxes Diner. Don't forget to subscribe both to YouTube and to Rumble here. And I look forward to talking to all of you again real soon here at the 4Boxes Diner.
Orders up. Table 2A.